Any mention?
Yes.
Please, Lordship. I beg to mention item 11. Lordship, it's a joint prayer. Yes, Your Lordship. It's a joint prayer, Lordship.
Okay.
After vacation, Lordship.
Joint prayer made with the parties. List after winter vacation.
Obliged, Lordship.
Yes.
Item number 13, Lordship. Item number 13.
Yes.
Lordship, in this matter, I am in the process of preparing my written submission, Lordship. So I request for another week's time, Lordship.
This you can't go after vacation.
Lordship.
You,
Lordship, in this
if you
matter,
submit it next week, it not be possible for this court to deliver a judgment.
Lordship, in this matter, we have submitted our
We
written
have already
argument.
submitted that. We have recorded. Anyway, just say on prayer of Mr. On prayer to Mr. Karmin Ji appearing for the state respondents. For that 2 weeks time is granted for filing.
Obliged.
Highly obliged.
May I please, Your Lordship? I beg to mention item number 12, my Lord. The similar matter is pending before the division bench, my Lord.
When that matter is likely to come before division bench again? Any idea?
No idea, no.
Okay, after 3 weeks, 12, I think 12.
May I please, Your Lordship?
Yes.
My Lord, I'm praying for some accommodation in item number 5 and 6, the connected matters, my Lord. I'm praying that these matters may be taken up after vacation.
What are the matter about item
The
5?
CMJ matter, my Lord.
Yes.
No objection, Your Lordship.
How many cases are there?
The two cases, 5 and 6. I'm the petitioner in 6.
I'm in the petitioner number 5, item number 5.
5 you were there.
Yes, Your Lordship.
In your prayer is in both the matters.
My Lord?
You're making prayer on both.
Yes,
the
my
matters.
Lord.
Okay. Yes, on the prayer made on behalf of your respondent number.
My Lord, for the state respondents.
Okay. Oh, okay. On prayer made on behalf of the state respondents. Mr. Nongri, Philemon Nongri.
Yes, my Lord.
Okay, just say one prayer made on behalf of Mr. Philemon Nongri, London Special Counsel appearing for the state respondents. Come on, not objected to by the London Counsel for the petitioners. List this matter after winter vacation. Yes.
Highly
Much
obliged.
obliged. My Lord, I'm praying for the same accommodation for item number 8 as well.
Who is there in item number 8?
Mr. K. Paul, my Lord. I've sought consent from the other side.
Are they here?
I'm
Item number
not
8,
a-
you were there for the petitioner.
Yes, my Lord.
Up that side. Oh, this side. And there is no one from.
No, my Lord, but I've informed them, my Lord.
Okay. You are there for the state here?
Yes.
Okay, just go. One prayer of the petitioner. I'm not object to the London GA. Mr. Just after vacation. Yes.
Much obliged.
My Lord, I would like to mention item number 14, my Lord. If this matter can come up after vacation, my Lord, we have to file one affidavit.
Item
14, my Lord.
yes.
No objection, Lord.
Prayer of the petitioner after vacation. Yes.
Obliged.
We please, Your Lordship. I beg to
Yes.
mention item number 15.
Yes.
This is a prayer that matter is still pending before division bench.
This items 15.
15.
Poxo.
Poksu, yes.
When it's likely to come, Mr.
It's supposed to be listed today's Lordship today because it
This
was
due-
yes today.
It is there today.
I heard like this Lordship, but I'm not confirmed.
We will
It's okay
postpone it
after-
after vacation. After vacation.
After vacation, Lordship.
In front of the parties, list after vacation. Yes.
Much one.
Supplementary causes, item number 1.
This is an application praying for early hearing of the matter. The matter is pending since 2016. Even today, up to now, only for maintainability. So
Early-
many dates have
early
come
hearing of which
for the maintainability of the matter.
Early hearing of which matter?
Early hearing of
which
a
matter?
title suit pending before the court.
Or not early hearing of this matter?
No, no.
Just tell us.
Yeah. My lord, if your lordship come to page 15, my lord, this is an order dated
1
4th.
minute, 1 minute. Okay. Matter arising out of land dealing.
Yes, my lord.
Suit was filed
Yes,
and pending for almost 10 years now.
yes, my lord.
You are the respondent.
Yes, my lord.
And you filed an application questioning maintainability.
Yes, my lord.
Preliminary issue was claimed,
Yes.
but then no disposal.
So only
What
on
is the last order of the court? That was pending from before separation, isn't it?
No, ma'am. Last date was on 17/9/7/25, my lord. Page 35.
Page 35.
Yes, ma'am. Date 9/7/25. Oh, my lord.
There is no page 35.
No, my lord, page 20. 35 is the interval. Page 20, my lord.
You filed a writ petition before also.
No, my lord.
There is an order annexed at page 28.
Oh, sorry, my lord. Oh, yes, it was filed. It was withdrawn. It was under 226. The court said it should be 227, my lord.
No, it was supposed to be taken up on 4th
Yes.
November. Then what happened?
Thereafter, another date is fixed in the month of March or something like that.
No, see page 35, page 20, page
Yes.
20. Why this is page double page marking? What is this 35?
I don't know. 35 was. It was taken from the record of the court. Maybe it was.
I should have cancelled it. Now what is this this on what happened on that day 4/11/2025?
Again, it was adjourned for the next date. It should come
But
after
then you have
vacation.
not next that's order sheet.
That
here.
order is not with me, my lord.
We are in the month of December now.
No, in December it is not. Somewhere in March it is fixed.
Hard. So the issue notice.
Your lordship, so it can be disposed of, my lord.
Without in absence of the respondent will be proper.
Because they will not be prejudiced in any case if it is.
We do not know. You see, it is only after order is passed.
Okay.
It will be unfair on the part of the court. Or if you can serve them advance notice, we can have it tomorrow, day after.
Difficult to serve where the.
This is address is Shillong.
Yes. But difficult. Let
Then
it
you have to take step. There's no other option then. Heard Mr. Siddiqui, my senior counsel, assisted by his sponsor. Issue notice. Returnable in 3 weeks. Petitioner shall take steps for service of notice upon the sole respondent within 2 days. List of 3 weeks. Yes.
Dairy causeless, item number 1.
My lord, here I have received the status report from the post office. We are going to file it today, Lordship.
Have they been, whether the
It has been delivered, Lordship.
this is delivered?
Yes, I'll file the status report.
But
That
no
service
appearance,
affidavit,
isn't it?
Lordship, today. Then file it today.
Mr. Sheikh Client Counsel, acting for the petitioner, submits that service of the sole respondent has already been affected. Stop. He prays for grant. He prays that an affidavit in support of an affidavit bringing on record the proof of service. Counsel, he says he submits that the service affidavit in support of the service will be filed during the course. During the course of the day. In view of the submission, this is matter after 2 weeks.
My lord, it can be fixed after vacation also. 2 weeks, no problem. It can be fixed after vacation also, Lordship.
2 weeks, it's automatically will go after vacation.
All
What
right.
is what date?
All right, Lordship. All right, Lordship.
Isn't it? 2 weeks after vacation. Just 2
All
weeks.
right. My lord, there is an interim, my lord, interim.
Interim order, first order shall continue till the next date.
Highly observed, Lordship.
Item number 4.
Your Lordship, Lordship, I have learned that evidence has already started. So let me withdraw with liberty to file first.
That is better.
The transfer.
Is it? Okay. Mr. SP Mantra, Ghana Senior Counsel, on instruction submits that the petitioner does not want to press this application.
I'm for the respondents.
Prays for liberty to withdraw the same with prays for permission to withdraw the same with liberty to file afresh. Mr. Kharmi, Learned Assistant prepares no objection. If you are allowed, this criminal petition stands dismissed on withdrawal with liberty as straightforward.
Obliged.
Hearing item number 7.
Well, this is a very old matter relating to creation of a restoration of a lost same ship. My lord, my learned esteemed friends say that
Yes.
otherwise I'm ready to advance my argument.
Lordship, my only difficulty is that this matter has been lingering now for 8 long years and repeatedly has been adjourned. So we might have a consensus that we fix a date so that we come prepared also. Or it will take some time. On the petition.
It'll take some time, madam. The matter. Then it will go to next.
After vacation, particular dates where all of us will come and address the issue, with Lordship permission.
You want to fix a particular date now, right now? For after vacation, you will fix it.
Yes, we will fix it after vacation.
Because your particular date may change. Yes, one joint request made with the parties. This is matter after vacation. This will take time taking.
It will take some time.
What is the issue involved? The
Restoration of the lost same ship, they call it. It was a same ship earlier, and it was lost, and the district council restored it after
Exactly lost, Lordship, missing.
missing. It's okay, whatever comes.
status of one ilaka. It was a CMC.
Yeah, it was the same
And
ship.
then
Yes.
And
Then
then
what
for,
happened?
And
for
there was no
decades,
king.
there was no same ship as such. And it was revived.
It was a right, then thereafter it was revived, restored again after examination.
so what is the cause of action right now then?
Well, they pass a formal order. District council pass a formal order. We challenge that one.
2017.
Recognizing. it again.
Recognizing?
Yes.
Yes.
So how then that means that goes in your favor? No.
In my learned friend's favor.
Okay.
It goes against
They
me.
are challenging.
there
We
are,
are challenging.
there are I mean contest so far as the
Yes,
status of
yes.
the Elaka is concerned.
Yes, yes. Right. Leave it over.
Item number 9.
Yes.
Your Lordship, this matter is challenging the impugned order against my application, rejecting which I filed under Order 7, Rule 11, Your Lordship, for rejection of the plain. Your Lordship, the ground that I have contended in the application for rejection of the plain, Your Lordship, is that it is barred by law under Section 126 of the TP Act, whereby the respondent, Your Lordship, had prayed for revocation of the gift deed which have been bequeathed upon me, Your Lordship. So, Your Lordship, in the plain, they had prayed for revocation of the
What
gift.
about the other side?
It's been proceeded ex parte, Your Lordship.
Ex parte proceeding?
Yes, Your
This is what has been ordered by this court.
Yes, Your Lordship.
Which order? Which date? It only says that none appears for the respondent despite service of notice. And then this was the last order. Is there any order to proceed ex parte against the?
It's fixed for hearing today, Your Lordship.
It's all right. But then, is it required for us to pass an order that we should proceed ex parte or not?
Whatever.
This is a civil matter, isn't
Your
it?
Lordship, pleases, Your Lordship.
What is the requirement of law? Just tell us. In a civil matter, if you have to decide a matter in absence of others, is there any requirement of fixing a date for ex parte hearing or not?
Yes, yeah, Your Lordship, that it be reflected in the order today for ex parte.
No, that is okay, but then what is the requirement? You just tell us. Why you are avoiding the issue? If you say it is no, then we will hear it out now.
Your Lordship, since in the last two, three occasions, you already have been absent, even despite the notice being served.
Yes, just proceed.
Your Lordship.
Proceed.
Your Lordship, the suit pertains to a plot of land which is situated at
Who filed the suit? The respondent filed the suit.
respondent, who is my mother, Your Lordship.
Respondent is your mother.
Yes, my mother. So they have bequeathed the property in my favor, Your Lordship, by registered gift deed, which is an annexure, which is at page 33, annexure 1, annexure 2 in the plain, Your Lordship.
Annexure?
Thereafter, yes, Your Lordship.
Just a minute. Annexure? Just say, tell us.
The registered gift deed, it's page 33, which is annexure.
Page 33.
Page 33, Your Lordship.
So this is a gift deed, registered gift deed by which she bequeathed her property to you.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
Then what happened?
Then thereafter, my mother instituted a suit against me, alleging that I had offered the property for sale to a third party. Your Lordship, what the contention in the plain is that
You offered to sell the land in favor of the other party.
Yes.
But then after gift, it property became yours, isn't
Yes,
it?
Your
It devolved
Lordship.
on you, isn't
Yes,
it?
Your Lordship.
Yes.
so. After that, the respondent instituted a suit against me on the ground that I had offered the property for sale to a third party, which they have contended in the
Was
plain.
there any bar
No, Your Lordship.
posed in the gift deed?
No, Your Lordship. There's no reserve right any as such in the gift deed. So, Your Lordship, they have.
What is the date of the gift deed? 13th day of August.
13th day of August 2021. The contention in the plain is that there's a verbal agreement, Your Lordship, that I should not sell the property to any third party. So, Your Lordship, accordingly, I contested the suit, filed my WS, and thereafter I filed my application under Order 7, Rule 11 for rejection of plain. So, Your Lordship, the trial court, despite the glaring averments in the plain, Your Lordship, had rejected my application. So, I've come before the honorable.
What ground it has been rejected?
Rejected that, Your Lordship can come. Page 15, Your Lordship, the last paragraph, paragraph 11. In the
First
present,
was take us to your application seeking rejection
yes, Your Lordship.
of plaint under Order 7 Rule 11.
Yes, Your Lordship. Page 57, Your Lordship. In the application, Your Lordship, I have contended that the suit is barred by Section 126 because Section 126 of TP Act stipulates that there should be a reserve right, Your Lordship, in the gift deed. Section 126 of the TP Act. It's barred by law under Section 126.
What Section 126 stipulates? Transfer of Property Act?
Yes, Your Lordship.
Wait, let us first just do not go too fast. Just
Yes.
let us see what grounds you have raised in your
Yes, Your Lordship.
petition.
My main grounds in
Page
the
57. Just give us which paragraph speaks about this.
yes, Your Lordship. The main grounds in my application is at page it's paragraph 8 of the application, Your Lordship, page 58.
Yes.
That the opposite party plaintiff had categorically stated in the pleadings via paragraph 10 pertaining to the verbal assurance and promise over the suit land, which is reproduced herein below, that the plaintiff begs to state that as soon as the execution of the said gift deed dated so and so, the defendant's malified intention and ill motive started showing when she offered the said suit land for sale without taking into consideration the verbal assurance and promise that the defendant shall not sell the said suit land to anyone whatsoever, and that the legal heir and successors, that's the defendant's children, shall inherit the same in the future as the legal and lawful owner. Your Lordship, in the entire pleading, Your Lordship, you can be seen that there's what the respondent had contended is that it's a verbal assurance, Your Lordship. There's no reserve right whatsoever in written form, Your Lordship. So, Your Lordship, on that basis, I had filed that application that it is barred by Section 126 because Section 126, a gift can be revoked or suspended only if there's a reserve right, Your Lordship. Your Lordship, if you can see the Section 126 is there, I've also stated there in the
What 126 says?
Section 126.
Give me a transfer of property act.
Your Lordship has got it. Yeah. The gift may be suspended or revoked. The donor and the donee may agree that on happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked, but a gift which the parties agree shall be revocable only or wholly or in part at the mere will of the donor is void wholly or in part as the case may be. The gift may also be revoked in any case, in any of the cases save one for failure of consideration, of which if it were a contract, it might be rescinded, save as otherwise the gift cannot be revoked. Your Lordship, the main point here is the first one, Your Lordship, the donor and the donation on the happening of specified event. There's no any agreement on that effect, Your Lordship, that if there's any in the happening of any specified event that the agreement that the gift deed should be revoked. Even if there is also, Your Lordship, if the gift is to be revoked wholly at the will of the donor, Your Lordship, it cannot be sustained, Your Lordship. That's what it's meant by this section, Your Lordship. Your Lordship, based on this, Your Lordship, filed the application that it is barred under this section.
Just a minute. No, it doesn't say, this is no reference so far as the oral agreement is concerned.
Your Lordship, there are some authorities also which states that there should be a reserve right in the gift deed itself. If there's a reserve right in the gift deed itself, Your Lordship, the
And if there is nothing specific in the gift, but then an assertion is made that there was verbal understanding, then what happens?
yes, Your Lordship, verbal understanding, it's
Is there any decision which says, or rather excludes that specific, exclude the verbal understanding, as has been said in this case, in the thing? Does it say that this will not be tenable in law? It's not admissible in law.
no, Your Lordship. What
If
the
you can
section-
show
yes, Your Lordship,
that their assertion in the plaint
yes, Your Lordship,
that there was a verbal understanding that you will not sell the land in favor of any
yes, Your Lordship,
other person, any outsider, and that basically that kind of verbal assurance
yes, Your Lordship,
is not admissible when there exists a registered deed of gift stipulating all other conditions.
yes, Your Lordship.
Is there any such decision which says that?
I've not come across the, such.
So
like
but
decision,
then
Your
what is your plea then?
Your Lordship,
Where is the bar, legal bar? Where is the legal bar?
the legal bar is that
Here it is nothing. 126 doesn't say about legal bar.
there should be a written express condition in the gift deed, Your Lordship, that either
No,
party.
but then does it say that there cannot be any verbal agreement in addition to what has been written, stipulated in the registered deed?
Yes, Your Lordship. However, Your Lordship, if Your Lordship can see even section 10 and 11 of the TP Act, Your Lordship, it condition restraining alienation and the restriction repugnant to the interests of created. Your Lordship, you can come to section 10 of the Act.
But then you have not taken any plea of section 10 in your petition.
And
Your
Your
sole
Lordship,
plea
because,
taken is
whatever has been
126.
whatever has been transferred to me, I'm become the absolute owner, Your Lordship. So if there's any condition as
No,
such,
no, but then you have not taken the plea of section 10 in your application seeking rejection under order 711. Have you referred? You have not. Your only ground taken is section 126.
yes,
That is what. So you confine yourself to that.
Yes,
In the revisional court, you cannot widen the scope.
yes, Your Lordship.
Then, so looking at section 10 basically becomes useless now, even if it says so,
Yes, Your Lordship.
in view of the fact that you have not taken that stand.
Yes, Your Lordship. Your Lordship, to substantiate my submission that there
No,
should
you
be
just,
a verbal.
You just give elaboration of 126, where it is barred, where is bars filing of a suit, or where. One 26 is when gift may be suspended or revoked.
Your Lordship, I have some authorities, Your Lordship, to show that section 126, there should be an express condition, Your Lordship.
This is a decision by which court?
This is Delhi High Court, Your Lordship. Lordship, if, the one which has been underlined, Your Lordship, in the present case, as in it is clear from the document itself, there is no agreement that on failure on the part of the plaintiff to perform any of the conditions, namely Sabadharma, etc., the gift will be invalid. In other words, there must be a deficiency or default clause in order to make the gift revocable. If there was a condition that if on failure to perform any of the conditions, the gift will be revoked, then certainly the gift would have been revoked. The document does not make any provision to that effect. Again, Your Lordship, the paragraph 40, the decision reported in so-and-so is also an authority on the point of revocation of the gift deed on breach of condition attached to gift.
Whether this court was dealing with the at that stage of orders 7 Rule 11 application
Yes, Your Lordship, they have filed
in this
for
case
revocation.
in
Yes,
Delhi,
Your
Delhi
Lordship.
High Court
Yes, Your Lordship.
in the similar facts and situation.
Yes, Your Lordship. If Your Lordship can come to paragraph 15.
Paragraph?
Paragraph 15, which is page... both the aforementioned application under 7 order 7 Rule 11 filed by defendants and application under 12 Rule 6 filed by a plaintiff were listed before the single bench. This is what they have contended, Your Lordship, the order 7 Rule 11 regarding revocation, Your Lordship. So, Your Lordship, this is what they have this on the Delhi High Court had observed regarding the revocation of the gift deed. At paragraph 40, Your Lordship, it is held that in the absence of the express reservation of a power of revocation of the gift deed, a donor does not continue to have the right to revoke a gift. For if a man will improvidently bind himself...
Just go slow. Just allow the court to come to the portion which you want to read out.
Paragraph
Ascertain that and then you go to the next thing.
Paragraph 40, Your Lordship.
Wait.
Paragraph 40 and 41.
Yes. Paragraph 40 and 41.
Yes, Your Lordship. If I may read, Your Lordship, paragraph
Yes,
40.
please.
The decision reported in so-and-so is also an authority on the point of revocation of the gift of breach of condition attached to the gift. The relevant observation made in the said decision are being noted here under. In the case of so-and-so, the High Court held that in absence of any express reservation of a power of revocation of the gift deed, a donor does not continue to have the right to revoke the gift. For if a man will improvidently bind himself up by a voluntary deed and not reserve a liberty to himself by power of revocation, the court will not lose the fetters he has put upon himself, and without reservation of the power to revoke. Gift cannot be revoked under section 126 of the Transfer of Property Act. And thereafter, Your Lordship, the observation of this particular case, it's at paragraph 41. If I may read, Your Lordship.
Yes.
To put it quickly, the position regarding the revocation of the gift upon breach of condition of gift in this, there must be a deficiency or default clause in order to make the gift revocable. If there was a condition that on failure to perform any of the conditions, the gift will be void, then certainly the gift would have been revoked. But the gift cannot be revoked where the document does not make any provision to that effect.
Okay, let us come to the gift deed then. Let us just see what
Yes,
the gift
Your
deed
Lordship.
says.
Gift deed, page 33, Your Lordship. This deed is made on that and so and so between Samiti so and so, daughter of so and so. This whereas the donor, if you come to paragraph 3, Your Lordship, whereas the donor is the absolute owner of a plot of land measuring an area of so and so, covered by deed of declaration dated so and so, and rectification deed so and so, lying situated at Nong Thamai, lying situated at the then Nong Thamai of United Khasi Jaintia Hills, presently at Nongram Hills. Shillong, East Cassius District, Meghalaya. Thereafter, hereafter called and referred to as the said landed property more particularly and specifically described in the Schedule 1 written herein below. And whereas the Smriti Natalie Sharon Batho, being the donor's daughter, the said donor has great love and affection for the said donee, and the donor, out of such natural love and affection, is desirous of disposing of a portion of her said landed property measuring an area of about so and so in favor of her daughter, more particularly and specifically described in Schedule 2.
So it is unconditional, basically.
Yes,
No condition attached.
No condition, Your Lordship.
Now come to the plaint. Where is the plaint?
The plane, it's 17, Your Lordship. All they have contended in the plea, Your Lordship, is that there is a verbal assurance and promise. The prayer is for decree to revert back the said suit land to the plaintiff, Your Lordship, to the respondent here.
Now paragraph 8. Then paragraph 8 of the plaint, isn't it?
Yes, Your Lordship.
Where is this land situated?
Norham Hills, Your Lordship. Norham Hills.
No, this suit land is possessed by the plaintiff. It is in possession of the plaintiff now.
Yes, Your Lordship. Ever since I was gifted, Your Lordship.
You are not the plaintiff.
Oh, ever since I was given.
So that is not in your possession. The suit alleges that it is in the possession of the plaintiff. Because you have left Shillong.
I left Shillong, Your Lordship.
So you are not in Shillong.
I'm not in Shillong, but then the moment I was gifted, Your Lordship, I intend thereafter, because there's some financial constraints, so I intend to sell it off, Your Lordship.
Now, if the suit is in the possession of the plaintiff, and the plaintiff is not contesting the suit, he is not received. It's very. Who are the counsel representing the plaintiff before the district council court?
It's Mr. Mertong, Your Lordship, in this council. In the show cause to my application also, Your Lordship, there's no positive challenge to my.
It doesn't
ground,
matter.
Your
You see, only we have to only confine to plaint, nothing else.
Yes, Your Lordship.
We do not look at any other evidence. Law requires us only to see the plaint and to see whether there is a bar posed by
Yes,
law.
Your Lordship.
Now, whether 126 would be a bar or not, is it not a subject matter to be adjudicated during the course of the suit?
But Your Lordship, as what has been.
It doesn't create any bar.
Yes, sir.
It merely says that, you see, in certain situation, gift cannot be revoked.
Yes, Your Lordship.
Like it cannot be a one-sided action by the donor,
Yes, Your Lordship.
isn't it? There has to be a joint willingness so far as the clause or the condition which would result in cancellation of gift. But then it has to be a clause agreed by both the parties.
Yes, Your Lordship.
And that has to be specifically provided in the deed itself, the instrument itself.
Yes, Your Lordship.
Is it correct? This is what the requirement of law, isn't it?
Yes, Your Lordship. And one
Now,
thing.
but then, what section Order 7 Rule 11 says?
It's barred by law, Your Lordship, clause D.
So where is the bar here?
It's barred by 126, Your Lordship. 126. It's barred by 126.
Does it bar filing of a suit?
On the face of the pleading, Your Lordship, it's.
Or it may be an obstacle so far as grant of relief is concerned.
What have come, Your Lordship, for to challenge is that on the face of the pleading, Your Lordship.
Let us see what is the ground taken by the trial court when rejecting your application.
Yes, Your Lordship. Actually, Your Lordship, on the day of the hearing, also the counsel for the respondent had made a concession that he wanted to withdraw without any condition. However, the trial court proceeded to hear the matter and passed the impeach order, Your Lordship. In that aspect also, Your Lordship, the trial court had committed an error of jurisdiction.
Now there is a submission by the plaintiff to withdraw the suit.
Yes, Your Lordship. And still the trial court proceeded to hear the matter and reject the plaint later.
Now see the order of the trial court, paragraph 6.
Yes, Lordship.
Now it only deals with the show cause filed by the plaintiff in response of your application.
Yes, Your Lordship.
Now where is the part which deals with your application?
Paragraph 7, Your Lordship, from paragraph 7 onwards. One perusal of the dispute, the plaintiff has sought cancellation of the gift deed on the ground that the defendant is acting contrary to the purpose and understanding upon which the said gift deed was executed. It is pleaded that the defendant had verbally assured the plaintiff that the suit property forming part of the ancestral land would be retained and used for the benefit of the defendant and her descendants and not alienated to any third party. The plaintiff's claim that she has now come claims that she has now come to know the defendant's intention to sell the property to a third party, violating the trust understanding under which the property was gifted. The plaintiff asserts that her intention was to ensure that the property remains within the family lineage. Although the plain does not contain specific express allegation of fraud or misrepresentation, a careful reading of the pleading indicates the plaintiff seeks to suggest that the defendant obtained the gift deed by suppressing her true intentions, acting contrary to the understanding that form the basis of the gift. Such contentions, while not explicitly frame and as fraud or misrepresentation, is inferable from the pleadings and touch upon question of fact which necessitates examination through evidence. It is settled principle of law that at the stage of deciding the application under Order 7 Rule 11, the court must confine itself to the averments made in the plain and cannot embark upon a detailed inquiry into a disputed question of fact, where the plain discloses cause of action and raises issue requiring adjudication upon evidence. It cannot be summarily rejected. In the present case, the plain read as a whole discloses tribal issues which cannot be decided without full-fledged trial. The defendant's contention that the suit is barred by Section 126 cannot be determined in isolation at the threshold, particularly when the plaintiff seeks to challenge the validity of the gift deed on the ground that suggests lack of informed consent or breach of trust, even if not specifically pleaded.
So, where is the jurisdictional error?
Your Lordship, the trial court ought to have confined to the pleadings, Your Lordship, not to look at the other.
It has confined, it has not taken into any other thing.
Yes, Your Lordship. Even paragraph 10, Your Lordship, it has.
Paragraph 11 says, in the present case, the client, read as a whole, discloses tribal issues.
Yes, Your Lordship.
So,
however, Your Lordship, in paragraph 10, you have observed that at the stage of deciding application, it must confine itself to the averments in the plain. However, Your Lordship, from what can be seen from this impugned order, Your Lordship, it has touched upon other facts also, Your Lordship. So, what is glaring in the plain, Your Lordship, it's palpable that the suit is barred, Your Lordship, because there's no express condition. And moreover, Your Lordship, it has crossed its jurisdiction because at that time it ought to have allowed the withdrawal.
what is the stage of the suit now?
And now it's for framing of issues, Your Lordship. Filing of suggested issues, Your Lordship. Filing of suggested issues.
This order is of 9 July.
9 July, Your Lordship. Another authority also, Your Lordship, in 126. There's another authority also, 126. This is the Supreme Court, Your Lordship, regarding Section 126, paragraph 12, Your Lordship.
Yes.
No doubt the gift validly made can be suspended or revoked under certain contingencies, but ordinarily it cannot be revoked, more particularly when no such thing is reserved under the gift deed. In this connection, a reference may be made to the provision of Section 126 of the Transfer Property Act, which provides that a gift cannot be revoked except for certain contingencies enumerated therein. And paragraph 14 also, Your Lordship.
Now, what happens if it is shown that this gift is obtained by playing some mischief or by misleading the donor?
Yes, Your Lordship.
Will it be covered under by 126?
Your Lordship, as can be from the plain itself, there is no.
No, see, like so far as the plaintiff is concerned, as what the court has understood,
Yes, Your Lordship.
that you have, the gift was donated, the land was gifted
Yes,
in
Your
your favor, on the understanding that you will remain here,
Yes, Your Lordship.
reside in the property which has been donated,
Yes, Your Lordship.
and you will run, you will see, you will be there with your family.
Yes, Your Lordship.
Now, after getting the gift in your favor, you changed and you ran away. Now, though what has been stipulated in the plaint is not been provided anywhere in the gift deed, that gift is made conditional upon the donor acceptance that donor will reside there, will not sell to any third party. Nothing has been provided. So,
Yes, Your Lordship.
but then what has been stated in the plain, it hits at the, you see, like at the very action by which a gift was made to you.
Yes, Your Lordship.
Basically, that the impression which you have created, that you will remain the thing, that has persuaded the donor to donate this thing. Now, if it is found wrong, can a gift deed be not interfered? Say like that, if any contention is raised that the gift was made in your favor by misleading the donor, will it be covered under 126? The
Your
fraud
Lordship,
has been,
yes,
whether
Your
the subject matter of fraud will be covered under 126.
If there is no pleading as such on misrepresentation of fraud, Your Lordship, I don't think so.
No,
That,
but then that is
Yes, Lordship.
that is otherwise it
Because-
is implied there
because even the
that
law.
you have changed yourself.
Yes, Your
Now the court, the question which the court is asking you, like whether if there is a allegation of you like inducing somebody dishonestly, or there is a misrepresentation, whether that will be covered under 126. What you say is very correct. 126 says that unless there is a specific stipulation made in the gift itself,
Yes, Your Lordship.
you see, it cannot be. Nothing, see, gift cannot be revoked
Yes, Lordship.
in any other ground. But then when any allegation is made, which basically raises a question, doubt, with regard to, say like, they say like the gift, normally as we understand, is made because of love and affection towards somebody. Now, if there is any falsity
Yes, Lordship.
in that very creation of love and affection,
Yes, Lordship.
will it come under the provision of 126, the bar?
As can be understood, Your Lordship.
And does it say 126 doesn't make any stipulation that apart from what has been stated in 126, there cannot be any other ground
Yes, Lordship.
for revocation of
Your Lordship,
gift deed.
coming to that, Your Lordship, Section 126 and Section 11 should be read in together, Your Lordship, because Section 11, Your Lordship.
It has to be read together.
Yes, Your Lordship.
And what Section 11 says?
Restriction repugnant to the interest created, Your Lordship. Where on transfer of property and interest therein is created absolutely in favor of any person, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner, he shall be entitled to receive or dispose of such interest as if there were no such interest direction. Where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such direction or any remedy which may have in respect of breach of thereof. Your Lordship, if there is a repugnant to the interest created in favor of the person who received the property, Your Lordship, that particular direction which is but the person received, Your Lordship, should not be taken as through direction, Your Lordship, unless if the property, Your Lordship, given by the other person obstructs the property of the donor, Your Lordship, then in that aspect, Your Lordship, it can be enforced the direction. This is what is meant, Your Lordship. So section 126 and 11, Your Lordship, should be read together, Your Lordship. Because the gift has been created with full interest, Your Lordship.
No, but then which way it answers the query of the court?
Your Lordship, because once the property is gifted, absolute right has been transferred, Your Lordship. Once property is gifted, absolute right has been transferred. So there should not be any repugnant to the interest, Your Lordship.
So there cannot be any sort of restriction.
Yes, Your Lordship.
And you see, like this, the creation, the interest whichever is created, it has to be unrestricted.
Yes, Your Lordship.
That is what you want to say.
Yes, Your Lordship. Yes, Your Lordship.
You see, like when the property is transferred in favor of the donee,
Yes, Lordship.
you see, this ownership is transferred. Absolutely, isn't
Yes,
it? That is something unrestricted. It cannot be regulated.
Yes, Your Lordship.
The so far as the interest and enjoyment over the property is concerned, it is basically unrestricted. There cannot be any restriction.
Yes, Lordship.
That is what you want to say, isn't it?
Yes, Your Lordship. Because the law also is in favor of the buying and selling, Your Lordship. It creates revenue for the state also. Now, if I'm not allowed to do anything on my property, there will be no generation of revenue to the state also, Your Lordship.
But then you are not staying in your property, isn't it? It is in the possession of the
Yes, Your
plaintiff
Lordship.
only.
However, Your Lordship, since the interest has been transferred, it's my right, Your Lordship, to.
So it means, say, supposing if any gift is obtained by fraud,
Yes, Lordship.
there is no protection in civil law. That is what you want to say.
If that's the case, Your Lordship, they should have pleaded in the plain, Your Lordship, that it should be cancelled on account of fraud or misrepresentation. However, here in the plain, it's a verbal agreement. What they have contended is solely on verbal agreement, Your Lordship, that it should not be revoked.
No, that is agreement means that is understanding. Since it is not in writing.
Yes, Lordship.
So you see, like I play fraud on you to impress you and procure the gift in my favor. Later on, when you detect it, you will not have any remedy.
I'm not getting Your Lordship.
Hmm?
I'm not getting the Lordship.
Say if any fraud is played by somebody in obtaining a gift in his favor,
Lordship.
there is no protection in civil law in such a case. Like, do you want to say that the gift made cannot be cancelled? Now let us assume,
Lordship.
just for the sake of argument,
Yes, Your Lordship.
that the cause of action, what has been stated in the plaint,
Lordship.
saying that there was a kind of undertaking or like impression created by you that you will reside in the property,
Lordship.
okay, and you will not move
Lordship.
out of station, will remain there. And you have agreed to do that.
Lordship.
But then later on, after getting the gift, now you are trying to sell it.
Lordship.
Now that is a kind of, like a violation of the understanding which you have created.
Your Lordship. Your Lordship, in the first place, if the donor intended that the property should be in the lineage, it should have specifically stated in the gift deed itself, Your Lordship. It should have been, there should be a condition if the property she intended to be in
That
the
I understand. See, we have you have understood it. Now, do you want to say that a gift deed cannot be cancelled for any other reason other than what has been stipulated in the gift itself?
Your Lordship.
This is the law.
Yes, Lordship.
Even if it is shown that gift was obtained by fraud,
Lordship.
this
That
cannot
would-
be ground for.
That would be a different course of action, Your Lordship. They should have come on of
No,
challenging the.
what they have stated in their plaint? What is the ground taken in the plaint?
Is that there's a verbal assurance that the
So that is what.
property should not be sold to.
Is it not will it not amount to misleading?
Your Lordship, we don't know whether there's such agreement or not, Your Lordship, because anyone can just claim that there's an agreement as such.
Now, what section order? What's Order 7 Rule 11 stipulates? It says that the bar
Lordship.
under law is itself discernible from the statement made in the plaint.
Your Lordship.
Now, where is that? Insofar as this case is concerned,
Your Lordship,
what you are taking is your plea. It is your plea. You can write it in your the written statement.
Your Lordship.
But then, where is that statement in the plaint which makes the suit not maintainable under Order 7 Rule 11?
Because Order 7 Rule 11 Clause D, Lordship, a vermin made in the plain which is a vermin made in the plain which is barred by law, it should be rejected, Your Lordship.
What is the plaint? Plaint is at page?
Again, it's page 17.
Your all page marking, there is double pagination in your thing. That is a problem.
Lordship.
Very misleading. All your pages 33 and all, it has pages, the other page marking, internal page 16, 15.
My apologies, Your Lordship, I just xeroxed it from the original.
Should have cancelled it.
Yes, Lordship. I'll remember that, Your Lordship.
Come to paragraph 7 of the plaint, page 19. What does it say?
That the plaintiff begs to state that the defendant, who is presently residing at Dubai, United Emirates, with malafide intention and with all motive for her wrongful gain.
See, with malafide intention, ill motive. For her wrong gain, forced and convinced the plaintiff.
She is not in Dubai, Your Lordship. She's now in Pondicherry, Your Lordship. As of now, she's in Pondicherry now. She's not in
Whatever
Dubai.
it is,
Yes,
that is
Lordship.
okay. But then it speaks about the intention.
Your Lordship, here
Now that is where it has been said that you have, with malified intention and ill motive, for your wrongful gain, force and convince the plaintiff.
that's not true, Your Lordship. It's not force or
And to
convince.
by way of any deed of transfer, yes, transfer of land out of the state, and then thereafter this thing. Now, whether that is correct or not. Now, whether this can be a ground, whether this assertion can be a ground for filing a suit.
This is just a mere contention, Your Lordship. It's not true that.
No, you see, if you say mere contention, then definitely you see, like even that argument also will not help your case here, because then we'll leave it to the trial court to determine it whether this contention has any, like whether it is correct or not, whether it is there is any truth or not. That will not help your case here. What this court is trying to derive, basically from you, that the bar itself is created by the statement made in the plaint. What Order 7 Rule 11 stipulates?
Order 7 Rule 11, Your Lordship. Clause D, Your Lordship. Order 7 Rule 11, Clause D. Where the suit appears from the statement in the plaint to be barred by any law, Your Lordship.
No, but then,
By
now
any
where
law.
is that bar? So far as the statement in the paragraph plaint is concerned.
Now, Your Lordship, here it's the law which barred. The law is that the woman, there's no such written, the agreement, there's no such written agreement, Your
It
Lordship.
doesn't say so here. It says that you have basically played fraud to get this gift deed executed in your favor. Misrepresentation. Now, whether that can be a ground for rejection of gift deed or not.
The law.
See,
Yes, Your Lordship.
two things. One is a conditional gift,
Lordship.
where condition is specifically stipulated in the gift itself.
Lordship.
Okay, that is not a unilateral condition.
Lordship.
You see, this is agreed by both the parties, and that is what precisely 126 is,
Lordship.
isn't it? Now, what this court is trying to know from you is that, can there be any other ground for cancellation of gift deed, or can a gift deed be cancelled, rather be specific, on the allegation that it was obtained by misrepresentation? And that is what has been 7. Now that just the paragraph 7 says. Now give us something, some decision where you say that even in case of allegation of misrepresentation is there,
Lordship.
126 will pose a bar for that. See, paragraph 8 also says that the plaintiff begs to state that the defendant misled the plaintiff by deceiving her in believing that the same. Now you said that there is nothing as such. These statements are there in the plaint. Now, when there is a clear-cut allegation of misrepresentation, deception, whether that will be covered under 126.
As far as the law, Your Lordship, 126.
What you have showed us,
Yes, Your Lordship.
what you have showed us,
Yes, Your Lordship.
this speaks about stipulation and conditions.
Yes, Your Lordship.
So far as revocation is concerned. Here, they are not seeking revocation on the basis of any stipulation made in the gift deed. They are seeking revocation because you have played fraud, or you have, you see, like played a deceptive role. You have deceived the donor to make the gift in your favor. Now, can there be a bar for seeking cancellation of gift deed because of 126?
I'll have to research on that, Your Lordship.
Probably you got what this court is trying to communicate to you. 126, as you have shown us,
Yes, Your Lordship.
quite convincingly, that yes, if there is no stipulation made in the gift deed, okay, that cannot be.
Your Lordship.
Basically, gift deed, the cancellation of gift deed cannot be sought in a suit without there being any specific stipulation.
Your Lordship.
And you say like that, there cannot be a one-sided condition, which basically gives power to the donor to cancel it. Or rather, say like there cannot be a clause which at the mere will of the donor.
Yes, Your Lordship.
Now that is also one thing which is barred by the
Yes, Your Lordship.
126, isn't it?
Yes, Your Lordship.
Now that stands at one thing.
Yes, Your
Now
Lordship.
here, if you see, take into consideration that the statement made in the plaint at paragraph 7 and 8. Now this speaks about misleading and deceiving the plaintiff, which is not at all covered by 126. Doesn't come under 126.
Your Lordship.
Okay. Now that assuming that what has been stated in the plaint is correct,
Your Lordship.
can it be a ground for cancellation of gift deed or not?
I'll have to do research on that aspect, Your Lordship. However, what the law has stated, I have given whatever is there in the law, Your Lordship. However, on that aspect,
Whatever you have given, that is so far as the condition is concerned
Yes, Your Lordship. There should be a condition.
in the gift deed.
Yes, Your Lordship.
But then here it is not. You see, it doesn't cover the area of which you have given. You read this paragraph 7 and 8 again. There's a specific statement.
Your Lordship.
The defendant misled the plaintiff by deceiving her to believing the defendant desired to return back to Shillong. Isn't it?
Your Lordship.
Now, is it not that it stands at a bit different footing other than what has been stated in 126?
My contention is, Your Lordship, is that once given, it's given, Your Lordship. Once given, it's given.
Even that is what. Once given, it's given.
Yes, Your Lordship.
Now, is that you see, that has been obtained
Your Lordship.
by misrepresentation? Can it be ground or not?
I'll research on that, Your Lordship. I'll satisfy.
See, we do not know. You may be correct, but then the query which court is putting to you may not be wholly correct. But then you have to satisfy the court.
Yes, Your Lordship. I'll satisfy
Okay,
the court.
that is one aspect. Say you go to bank,
Your Lordship.
convince the banker, obtain loan.
Your Lordship.
Okay, then subsequently it is found that you have basically misrepresented.
Your Lordship.
You see, you misled the bank authority in grant of loan. Now, can you come and say once given is given?
Your Lordship.
Okay, that is loan. Here it is gift.
Your Lordship.
Loan is something which is recoverable. Gift is basically not supposed to be taken back
Your Lordship.
until and unless there is a specific condition stipulating it. Now, what what this court understands is that had there been any stipulation made in the gift deed, that in case
Your Lordship.
the donee wanted,
Your Lordship.
in case the donee wants to sell it to third party, the gift will stand cancelled.
Your Lordship.
Property will stand reverted back to the donor.
Your Lordship.
Now, in absence of any such stipulation, you cannot cancel it. That is what you want to say.
Your Lordship.
Now, this court has found out something else in the plaint, wherein it says that you see this gift was basically executed in your favor on misled by your stipulation, though it has not been incorporated as a condition.
Yes, Lordship.
But then there is an allegation that the very execution was under some misleading, some misleading fact or deception. That is what they have stated. Now, whether that is the ground, will stand covered by 126.
I require some time, Your Lordship, to research on that, Lordship.
If you can show us that even if such kind of assertion is made in the plate, but then if the gift deed doesn't stipulate it in specific way, now this also cannot be a ground. The counsel who represents the other side, he is not a counsel here in the High Court.
No, Your Lordship.
He doesn't come to High Court. If you see the trial court's observation, at paragraph 11, it says in the present case the plaint read as a whole. Now that is what he has not specifically confined to those things. He says that read as a whole discloses triable issues which cannot be decided without a full-fledged trial.
Lordship.
The defendant contentions that the suit is barred under 126 cannot be determined in isolation.
Lordship.
So this is also on view court has taken that. Or at the threshold, particularly when the plaintiff seeks to challenge the validity of the gift on ground that suggests lack of informed consent or breach of trust. This is precisely this court is also asking the same question.
Lordship.
Now, 126 doesn't take care of this two aspect. Even if no specifically pleaded.
Lordship. I'll satisfy the court on the next, Your Lordship, with regard to the misrepresentation of fraud, whether 126 will bind or not.
You just take care of that paragraph 7, 7 and 8.
Yes, Your Lordship.
Because apparently the trial court also has taken the same view which this court is right now talking about.
But one thing is that the trial court, Your Lordship, ought to have allowed the application for withdrawal, Your Lordship, at that point of time. However,
That is all right.
Yes, Your Lordship.
But then, but then it seems like that he has not given much weightage to those things.
Right.
Rather, he has decided on the basis of the overall reading of the plaint.
Lordship.
Okay.
Lordship.
And has taken opinion which this court also more or less agrees until unless you can show something else.
Lordship.
Just say.
Lordship, it may be fixed after vacation, Your Lordship.
This has to go after vacation because you see whatever the thing whether it's contested or not contested,
Yes, Your Lordship.
court has to pass an order, a reasoned order.
Yes, Your Lordship.
Civil matters are very complicated
Your Lordship.
and this court doesn't know anything about civil law. So it will be totally dependent on you.
Your Lordship.
So you have a bigger responsibility not to mislead the court.
Yes, Your Lordship.
In absence of other side, you can do anything, isn't it? So that is where you have to be mindful of. Okay. Just say Mr. So and so, counsel is present on behalf of the petitioner. None appears for the respondent. The learned counsel for the petitioner 6 grant of some time to look for the authorities in support of the assertion made in this petition, made in this revision petition. What is it? Learned counsel? Place for, just place for, just make a place for. Then you say, last year, prayer allowed, list after vacation. You want it to remain here, those citations?
Yes.
Thank you.
Your Lordship.